Reshaping a Greater New Orleans Criminal Justice is made possible by Baptist Community Ministries. Founded in 1924 as Southern Baptist Hospital, Baptist Community Ministries is committed to the development of a healthy community, offering a wholesome quality of life to its residents and to improving the physical, mental, and spiritual health of the individuals they serve. Baptist Community Ministries is a nonprofit private foundation registered in the state of Louisiana and is committed to the Greater New Orleans region. For more information, visit www.bcm.org. The jail is real, but these scenes from inside it seem anything but.
We have not seen the sort of change that one would expect, or that we think the urgency of the situation merits. The reality is that our clients' lives are on the line literally every day.
Our facilities are challenged. The facilities that were built in the 1920s were not meant to model what's happening in today's modern corrections.
There are lots of really old jails that operate all around this country that are significantly safer than this facility here. And a building does not make or break whether one runs a constitutional or safe jail. If the Sheriff's Office doesn't take other steps that are required by the consent decree, then the new facility won't be constitutional any more than the current facilities are.
Unless the culture inside the jail, and when I say culture, I'm talking about how this jail is actually run, is changed. Is there some accountability from the folks who is running the jail, that we're going to have the same old thing.
The argument that we have been making with regard to the jail is that this is more of a management issue than it is a money issue. So the city doesn't run the jail, but courts are about to hold city taxpayers and the city general fund accountable for funding reforms.
The city of New Orleans will pay the price for years to come because of decades of problems in the jail and in the police department. Problems so severe, both are under federal consent decrees.
What the consent decree does for us this generation is it gives the ultimate protection that those policies and procedures we create that make us a great department can't be replaced by a new team or be forgotten by a new team.
For the next hour, WYES continues our series on the drive to improve the city's criminal justice system post-Katrina. Reshaping a Greater New Orleans Criminal Justice, change by decree. Hello, I'm Marcia Kavanaugh, Community Projects Producer for WYES. Our city is under two very costly, very comprehensive consent decrees. This program will update their progress. We begin with the question which Loyola University New Orleans School of Law professor Dane Ciolino will answer. Exactly what is a consent decree?
A consent decree is essentially a settlement of a dispute where the parties agree to a resolution, present it to the court. The court, after holding hearings and evaluating the fairness and appropriateness of the parties' agreement, then will sign on to the consent decree and make it essentially an order of the court that becomes enforceable through the court's contempt power. That is, if either party decides later on that they don't want to abide by some of the terms of the consent decree, they can be held in contempt. The pattern and practice of unconstitutional searches and seizures and excessive force by the New Orleans Police Department and the deplorable conditions at the jail are simply as a result of years of neglect or worse. We're in a place that put the city out of compliance with federal law, both the federal Constitution and various federal statutes. So at some point the city's just got to pay, and that's what these consent decrees are all about. The city stepping up and finally taking its responsibility to bring law enforcement in this city into compliance with federal standards. The Department of Justice has entered into similar consent decrees with a number of other cities throughout the country. So what the city is going through in that regard is not unique or even terribly unusual. What is unusual here is that the whole law enforcement community, involving both the sheriff and the police department, both find themselves under what are becoming financially oppressive consent decrees. But they are consent decrees that are the result of the city's own past misconduct, neglect, and worse. So it's unfortunate that the city finds itself in this position, but it only really has itself to blame for years of malpractice in law enforcement.
Mayhem. That was the description the lead monitor assigned to reporting conditions at the jail to a federal judge gave him in March. We will not hear from Susan McCampbell in our story. The consent decree prohibits her from interviews, but we will share the viewpoints of the sheriff, jail watchers, and two families whose loved ones died in custody.
That dead, we rolling like a dog in here too, you heard me? This biker things, you heard me? M357s, you heard me? This is how we coming, man.
These are scenes inside the New Orleans jail, apparently shot by inmates around the year 2009 in the since-closed House of Detention. Prisoners with drugs and weapons and other contraband, as if no one on guard was watching. The videos made their public debut at the New Orleans Federal Courthouse in April of 2013 during fairness hearings on the consent decree, a 49-page to-do list that the sheriff must complete to make his jail comply with the U.S. Constitution.
That I will support the Constitution and laws of the United States.
Marlon Gusman begins his fourth term as sheriff, eager to finish the new jail facilities he's been building with FEMA funds he's negotiated since the Katrina floods.
Every single facility that we had over 12 facilities, over 7,523 beds, was destroyed by Katrina. So we brought some back, and we began the process actually in 2006, 8 years ago, to start construction. And the city has not constructed a single bed. It's the responsibility of the city to do that under state law. So the law enforcement district has replaced, and we're about to open 1,438 beds.
It was Sheriff Gusman's request for help with jail staffing and emergency preparedness from the National Institute of Corrections in 2008 that began the path to the latest consent decree. Litigation over conditions at OPP has been going on for more than 4 decades. The NIC found what it called pervasive and long-standing problems. The Department of Justice made 3 visits to the jail that same year. It wrote the sheriff in September 2009 that certain conditions at OPP violate the constitutional rights of inmates, and found in particular that inmates confined at OPP are not adequately protected from harm, including physical harm from excessive use of force by staff and inmate-on-inmate violence, and also found inmates don't get adequate mental health care, including proper suicide prevention. An update letter in 2012 from the Department of Justice blasted the sheriff for failure to take basic steps to correct the issues DOJ identified. Justice said its April 2012 visit uncovered shockingly high rates of violence and pervasive sexual assault. DOJ wrote the sheriff, "The conditions in OPP fail to meet the most basic obligation of prison officials to provide humane conditions of confinement."
I think people would be shocked if they understood how serious the violence is in the facility.
Just before that 2012 Justice Department letter, attorney Katie Schwartzmann, then with the Southern Poverty Law Center, filed a lawsuit demanding action at the jail. She's now co-director of the MacArthur Justice Center and remains lead plaintiff's counsel for Jones versus Gusman, a major driver of the consent decree.
About 2.5 years ago, we received requests from the family members of some of the kids that are housed in the jail. And those family members were concerned about serious ongoing violence there and injuries that were resulting to these kids. In response to those phone calls, we went out and did interviews with the kids and started interviewing other prisoners about what they had seen. And as soon as we started doing that, the phone immediately started ringing off the hook with both family members and prisoners themselves asking for help to address the conditions at the jail.
Civil rights defense attorney Mary Howell has represented people in the jail or their families for decades. We asked her if she's seen progress since enforcement of the consent decree began last year.
The short answer is no. Part of it is that the problems are so profound and so chronic and so widespread that there just hasn't been sufficient time for the consent decree to really kick in. And the consent decree really is about long-term solutions. And it's going to take a while to dig our way out of the problems we're in. The other problem is questions of leadership and of commitment. There's not a sense, I don't think, in the city as a whole that fixing this problem is a priority. So there seems to be a lack of a sense of urgency and a lack of a sense of really deep understanding of what it's going to take to have a constitutional jail. So it's, right now, I can't say that I can see any real improvement. The good news is that we do have a monitor who's active and engaged and very knowledgeable. Under the consent decree, finally, after years of asking for this, the sheriff has been required to hire a corrections expert to at least advise him on how to run the jail. That's new under the consent decree. But the violence is basically relentless. And there's been no drop in the violence. If anything, there's been a slight increase. And I think you can still say today, it's been 2 years since that lawsuit was filed. It's been over a year almost now since the findings by Judge Afric in the consent decree. It was June of 2013. I think you can almost safely say that in substance, nothing has really changed yet.
In his order placing the consent decree in motion, U.S. District Judge Lance Afric wrote his conclusions on the fairness hearings. Those hearings unveiled these infamous inmate videos and nearly 300 pieces of evidence and 4 days of testimony. Jail security expert Jeffrey Schwartz worked with the Department of Corrections in more than 40 states over 35 years. He testified OPP was the worst jail he'd ever seen and likely the worst large city jail in the United States. Schwartz told the court OPP is plagued by suicides and other in-custody deaths, rapes, stabbings, and severe beatings.
Look, I'm not going to get into the testimony of people that were hired by the plaintiffs to make a point. You know, they were hired by the plaintiffs to make a point. I'm moving on. You know, I'm not going to worry about what their opinion is. If you ask 15 people, they're going to have 15 different opinions. The fact is that our suicide levels, our death levels, all were within national averages. But that's their opinion, and I'm not going to discuss it. I would not agree with them that one is at great risk of harm. Certainly, we have a community in a city that has violence in it, and the people that come into jail are the people that are most violent. Those are the ones that judges determine cannot be outside in the community. So we're going to have violent people inside of the jail. So classification is something that we've been working on. We have a classification program. We have one of the monitors who's been working to validate our classification program. But classification also depends upon having the proper space, having the proper locations to place people in. We're going to be opening our new building in about 3 or 4 months, and we really think that's going to have a very positive impact on our ability to have the proper locations in order to put people.
The fairness hearing shined light on the jail's lack of a classification system, the screening and separation of inmates.
And for people who are outside of jails and prisons, if you just think common sense, you got a lot of different people in jails. You got people who are in for traffic offenses, missing court dates. You've got people who most people would consider shouldn't even be in jail in the first place with very minor offenses. You've got people who are mentally ill. You have people who are vulnerable. You have people who are potential victims. And you have predators. You have some heavy-duty people in there who have committed serious offenses. They've either been convicted or they're pretrial. They have extensive records, but they are a danger often to themselves and others. And it's sort of Corrections 101. You need a good, sound classification system to separate these groups of people, separate these vulnerable populations. And a lot of the injuries that we see happening in the jail involve vulnerable populations. And as long as you don't have a functioning, well-crafted classification system, you are going to have people in serious danger. And we have really not had a satisfactory system in this jail for many, many years. And I think that's one of the real causes for the violence in the jail today, the lack of staffing, the lack of an adequate classification system, the lack of activity. People are crowded into these cells with nothing to do and under very difficult situations, and it's a very stressful situation to begin with. And you've got a lot of young people in there also that, and some of them are charged with very serious crimes, and it's a very volatile situation, and it has not been properly managed.
The consent decree plaintiffs counted 607 transports from the jail to emergency rooms for injuries and mental health crises in the first 10 months of 2013. A similar jail in Memphis saw 7 during the same amount of time.
We have dozens of clients who have broken eye sockets, broken jaws, fractured orbital fractures. There are all sorts of pretty severe injuries, including specifically a lot of stab wounds.
So, we don't have here at this facility an emergency room. Prior to Katrina, we did have what amounted to an emergency room. We don't have that. So we operate out of an abundance of caution to send someone. Normally, and this is, I'm saying normally, but the average person might say, oh, somebody got, the other day someone went there for a knee problem. I'm like, well, why do you go to an emergency room for a knee problem? But, in the opinion of the medical professional, they ought to go there and be evaluated because they had some other condition. So you can't just look at numbers, and you can't just look at some descriptions without knowing the whole story. The whole story is that those don't just include violent acts. They include every trip that we make there, and they include medical appointments. They include other reasons why we go to the medical emergency room. So, look, I said in the beginning, violence. We have violent people that we incarcerate here. Do they engage in violence? Sure, they do. And what our obligation is to take each individual instance and to make sure that we're making the right decision. And someone who is in need of medical care, we're going to make that decision in an abundance of caution and take them there. And I don't make any apologies for that.
It was a statement the sheriff made about an abundance of caution in an inmate's hospital treatment that led Deputy Bryan Collins to leak pictures to the media. Collins was a guard in the jail for 4 years and resigned in December. He was on duty in a juvenile dorm last June when an inmate tier representative in charge of serving breakfast threw a plate of hot grits in the face of detainee Brian Ellis and stabbed him 20 times with a shank.
Now, I've just witnessed this from the beginning and the entire thing play out. And that's why I took the picture. I said, you know what? I can't let this young kid nearly lose his life because I thought he was lifeless when we finally went onto the dorm, and nothing be done about it. And as time went on in the following days and weeks, sure enough, there was very little activity around it.
Collins says he was the sworn commissioned deputy on the scene, yet was never questioned.
You always interview that person. I was never talked to, and that's when I felt that they were going to let this go, as they let so many other serious, egregious attacks and events go by the wayside. There was an article on the incident where Guzman says an inmate was sent to the hospital out of an abundance of caution, and that his injuries were superficial and just scratches, minor scratches. I said, no, this can't be. You understand? I was directly involved with that, and I have a duty and I have a responsibility to not only the law, but to the public. That young man had a mother. I'm sure he has maybe siblings and what have you, and he expects me to do the right thing. If the administration won't do the right thing and pursue this thoroughly and get to the bottom of it, then I'll let the public be the judge and let them see if these are superficial scratches. And the picture just spoke for itself. I'm glad I did it, to be honest with you, because if I wouldn't have, Bryan Ellis never would have gotten justice. And the justice that Bryan Ellis got out of that event was that what went from being just another day in Orleans Parish jail with another violent inmate attack ultimately wound up to his attacker being charged and convicted of attempted second-degree murder.
The attacker, Edward Dean, pleaded guilty. Before Collins leaked his photos, he had been sharing information with the plaintiff's attorneys in the suit that led to the consent decree. He says he did it because his superiors refused to take action on his repeated reports of problems in the jail. Collins filed a whistleblower lawsuit against the sheriff, seeking $1.5 million in damages, claiming he was forced to resign out of fear for his safety. He is still speaking out about what he witnessed firsthand.
The lack of training and the lack of accountability truly breeds and invites the kind of conditions that you have there now. Even though many of these young men and women are admitted to the Louisiana Post Academy and they get their certification and they get their Sheriff's Department commission, they do not enforce the laws that they swear an oath of office to enforce. Once again, what happens in a jail, if it's a second-degree battery on the street, it's a second-degree battery on the jail. If it's a sexual assault on the street, it's a sexual assault in the jail. They do not enforce those laws. There's some good deputies there. By and large, most of them are lackadaisical at best and just downright lazy at worst. But that is the culture. It trickles from the top down. If you don't have a command staff that demands and expects any better, then you're not going to have a frontline staff that commands and expects any better. And therefore, there's no incentive for anyone to do better.
Collins believes the suicides and suspicious deaths also point back to the lack of accountability.
I had the benefit of speaking with the family of one of the most recent suicide victims, and they still can't get answers. They can't get answers as to how is it that their young, vibrant, very sociable, well-liked and popular son and brother managed to hang himself in a cell that was less than 10 feet away from a supervisor's office that was occupied by the supervisor. How does that happen? And to this day, no one is accountable.
I mean, we had a series of deaths this year that were really troubling to us. A suicide that we think was completely preventable. One of the major components of our case is that the facility has failed to identify and respond to people with mental illness or that are suicidal when they come into the jail. And that, unfortunately, we see that continuing. There still is a lack of psychiatrists, there's a lack of social workers, and the deputies just are not trained in responding to people with mental illness.
Both Bryan Collins and Katie Schwartzmann are talking about the hanging death of Clifton Morgan on September 28th. He was the 42nd person to die in the New Orleans jail since April 2006.
Like, okay, my brother was the 42nd, and others have came before and after. At some point, it has to be taken serious. You know, you have families suffering. you know, looking for answers, and nobody can tell them anything, yet these inmates are in your care. And all you can do is just say, oh, we're saddened by the news, et cetera, but that's not helping us. I mean, you guys know what happened. We don't, and we can't seem to get answers.
Clifton Morgan was a 28-year-old bounce artist arrested for a probation violation just days before his death.
When they booked him, he called to let me know, that he loved me and that he was going to be okay.
His family says Morgan had a mental health treatment history and was taking medications. They say jail officials told them Morgan claimed he was suicidal.
So the question is, I mean, if he's right across from a watch commander, it takes time to do what was put in place. So how did nobody catch that?
And the actual, the way they said it happened, it didn't make sense to us. Because if you're 10 feet away or however many, feet away from him, how you not see this, how you not miss this, if this is all glass? You didn't see it because probably either you wasn't there, or probably you were asleep, or you just didn't care.
He was less than 10 feet away from him. But the watch commander, and I'm not going to discuss more of the case, other than to tell you that the watch commander had just checked on him. They just checked on him. It's a misconception that people have that of how they do the suicide. It's not a overt thing where you're hanging from somewhere. It's a very subtle thing. So, but again, to get into the details of each case, I can't do that right now. The numbers are not high. In a facility like ours, when you have one, that is high. So what can we do? We can do better questionnaires, questioning people. We can do a better job at monitoring people. It's unfortunate, though, that if someone's determined to do something, they're going to do it. And you can do your best to try to stop them, and that's what we try to do.
They wonder why events like this is taking place. Nobody is being that serious. Because if they love one, they will go there. They will push it till they can't push it no more. That's all I want, is to fill the holes, give us the answers that we need, and we can go from there. We can move on as a family.
These are his beautiful children, Michael and Catherine. And this was his last Christmas with them.
The family of Michael Hitzman understands the Morgans' pain.
You can see he's got a smile on in every picture. It was very easy to catch him with that beautiful smile.
Hitzman was a phlebotomist and medical transcriptionist whose parents say struggled with depression and addiction.
He had a back injury, and he was under his wife's insurance program, and he was taking medication for his injury there. They were having some marital issues, and she left town, and he was dropped out of her insurance program, and so he lost his insurance. So once he couldn't get the medication that he needed to legally, he went on the street. And it was a sad thing for us. Very sad to see how addiction really works.
On April 16, 2010, a bail bondsman delivered Hitzman to the jail's Intake and Processing Center for missing a court date on a heroin possession charge.
He tried to speak to the medical personnel, and basically he was being ignored. He basically told them that I'm suicidal and that I just took a bunch of drugs and I need to go to the hospital.
And he said he felt like he was going to have a seizure. And so he was trying 7 different people to take him to the hospital. Nobody paid any attention.
He was basically being ignored.
Hitzman was sitting and walking around the intake processing center until a deputy thought the behavior was suspicious and locked him in a single isolation cell.
He went through the processing center approximately 5:30, 5:45, and he was dead at 7:15. They found him at 7:15.
but he'd been hanging for over an hour before someone
So it was
saw
seen,
him.
you know, the cell that he was in had a direct camera on it.
And his suicide was actually videoed, and was being, but no one was watching the monitors. And his death actually was really shocking, because a lot of the defense that the sheriff raises, and there's some legitimacy to this defense, is that he has old, rundown facilities and he's working under difficult circumstances with, you know, bad buildings, and that's true. But Michael Hitzman's death happened in a new building, in a modern building, in a building where you had video monitors. But if you don't have people who care, you don't have people who are doing their job and watching the video monitor and then intervene, you know, Michael hung there for an hour before he was found.
According to OPP protocol, deputies should have checked on him every 15 minutes. The 31-year-old hung himself, tying his shirt to the bars of the isolation cell.
This place is extremely bad, worse than you could ever imagine. And I don't want anybody's loved one to go there, because they might not get out.
The first compliance report by the consent decree monitors was filed February 13th in New Orleans Federal Court. It assessed the first 2 months since the judgment took effect October 21st of 2013. The monitors wrote they were encouraged to see efforts the sheriff's office had made to begin the journey towards compliance.
This isn't a consent decree to be average. This is a consent decree to be well above average. So we have to reach that goal. What we've been doing is working within the framework of what we have right now. What we have right now, old facilities. One facility built in the 1920s, another built in the 60s as a hotel or a motel and converted to a jail. We have temporary facilities, tents. So as we get through all of that, I think, you know, the issues of sanitation, the issues of staffing, the issues that we have to deal with are really going to be handled quickly. So one of the things that we've been working on, for example, is our policies, reworking all of our policies and then training everyone in the rework of the policies so that we can have policies that meet, again, this highest level. So we think we're making a lot of progress on it.
The monitors wrote they did not expect to see many items in compliance in such a short time span, but they said inmates held by the Orleans Parish Sheriff's Office continue to be at risk of serious harm, and insufficient staffing tops the list of reasons why.
You cannot have tiers in areas of this jail that have no guards. You just can't do it. And the thing that has been bewildering to me is still today there are long periods of time when there are no guards on these tiers. There will be like one guard who's responsible for watching an entire floor that has like multiple tiers. And that is an extremely dangerous situation, both for the guards, the people who work there, and for the people who are being held there. And I don't even know the answer to this question. When I first saw what was happening there with the violence, my question was very simple. Why do we not have all hands on deck? I see deputy sheriffs all over town. I see them doing details. I see them doing all kinds of other jobs. And it seems to me one of the core functions of this sheriff's office is to run a safe and humane facility. And my question is very simple, and it may be just a temporary fix. Why is there not been a call to shut down whatever else you have to do in non-essential services? Get those people in the jail now. Do not let there be a single tier that is unguarded or that is unsafe.
First of all, our deputies work a 12-hour shift. So you may not have known that. When you work a 12-hour shift, there's built-in overtime. So they're working a 12-hour shift. It is all hands on deck. Staffing is our biggest issue. Recruiting deputies is something that we have been doing. We're going to keep doing it. Pay, a big issue. I've been saying for years that we're the lowest paid law enforcement agency in this region. And Recently, with the help of the consent decree, with the help of the judge, we've been able to increase our starting pay from $9.69 to $12.10. That's been really positive. Still need to do more. Still need to do more. We're working hard. We work 24 hours a day, 7 days a week. We don't close, and we're responsible for intake, moving people to court, moving people to medical appointments, moving people in and around the facility. So there's a lot of work here, and the facilities themselves are difficult. So I mentioned that earlier, that when you have a facility that's built in the 1920s, that's not designed for modern corrections, it's going to make a big difference when we open this new modern facility that's currently being constructed.
The state-of-the-art new jail is designed for deputies to work face-to-face with the inmates they're supposed to care for and control. The inmates will live in 2-tier pods with 30 cells that can sleep 2 people. Each pod accommodates 60 inmates. Each wing of the jail's housing area has 2 pods. The large open common area is the day room. The guards will work at a station on the floor in front of a glassed-in watch office and control center. The bright and big space with a guard's view of the entire pod is a dramatic contrast to the dark, narrow, linear design of Old Parish Prison, where the deputy's desk is outside the tier door. And what goes on inside the cells is out of sight unless a guard walks the corridor. The new jail's design changes not simply the architecture of the OPP, it alters the relationship between deputies and detainees to what's known in the corrections world as direct supervision.
Which is placing the deputy inside of the living module, the housing unit, where the deputy can model behavior, where the deputy can monitor behavior, where the deputy can sense problems better before they happen and be in control of the environment.
Sheriff Gussman sent teams of command staff and deputies to train at the Caddo Parish Correctional Center in Shreveport. It's the only place in the state using a system that's made hundreds of U.S. jails safer since the mid-1980s. In Caddo, direct supervision begins at the booking process.
We explain it to them that if they ever need anything, we're here for them. We're here to protect them, make sure that they have everything that they need.
In the housing units, the same deputies who give the orders are in charge of the exchange on laundry days. Their workstation is out in the open in the day room, where they can watch with their eyes and with digital technology. When inmates are out of their cells for privileges and recreation 3 times a day, deputies are in the cells, sorting through possessions, searching for weapons and contraband. It's another way deputies take control through direct supervision of prisoners.
We get to know who they are. You know what things to look for. You also get to know when they're having a bad day. You know if they're upset. You know, those things, or if they've got bad news from their family, those are ones of things that you want to look out for, because sometimes, you know, they do need that help. And it's easier to identify when something's wrong with them. You know, as long as you come in and you're firm, fair, and consistent, these inmates will understand who you are. They'll know what you expect for them. And it's going to take some time. It's never something that you're going to get overnight. But being firm, fair, and consistent with everything and having them follow the rules that you want them to follow, they'll do what they need to do.
When direct supervision arrives in the new jail in New Orleans, the federal monitors caution talent and resources are needed to make it work. Jail watchdog Norris Henderson says it can work, but only with a cultural change. He runs Voice of the Ex-Offender and is part of the Orleans Parish Prison Reform Coalition. The death in March this year of inmate Willie Lee was inside a temporary housing tent, where a form of direct supervision is already used.
There was direct supervision there. Somebody was standing right there, watched the whole fight, and didn't intervene. So direct supervision depends on who is the person supervising and the type of rapport that has been established between that person and the person that they're in charge with watching out for. And if that don't change, if there's no respect across those levels, you're gonna have the same problems. That culture really has to change inside of that environment, because when you look at some of the people who've been back there, the career people who's been back there, some of the people who's been back there for better than 40 years. Well, those correctional practices from 40 years ago don't even exist no more. And whether or not there's been a push to bring these people up to snuff, get them in a drop program or something, so you can kind of like start changing the culture, because the culture is created by people, you know, not buildings. I mean, you can get a smack brand new building, but if we got the same people that's operating this building, we're going to have the same results.
The monitor's first compliance report concludes the conditions at the jail that resulted in the consent decree did not happen overnight, and solutions won't be achieved overnight. There is a substantial amount of work to be done to comply with the judgment and remain compliant for 24 months. The city of New Orleans fought in court for a federal receiver to take over jail operations. Judge Lance Afric refused. City Council Criminal Justice Chair Susan Guidry says maybe they should try again.
Frankly, the mayor called for receivership, and I'm in total agreement with that. Unfortunately, the law is very strict about receiverships, and you have to apparently go through months and perhaps years of this kind of trouble occurring, as we're seeing now, before under the cases that exist, before receivership is considered appropriate. I think that we should, again, try for the receivership based on the level of violence that's happening in the jail.
People involved in the debate over the ultimate size of what was supposed to be a 1,438-bed new jail think the scope and cost of the consent decree may play a role in the final decision.
We've made the argument in court. We've made the argument to the Secretary of Corrections. We've made the argument in the community that the city of New Orleans should not take on the responsibility of the state of Louisiana for jailing Department of Corrections sentenced felons. And so, for example, we are currently housing well over 500, almost 600 inmates at the jail who are the responsibility of the state of Louisiana. And in an era where I guess we've got all the money in the world and can afford to subsidize the state, that may make sense. But in the world we live in, subsidizing the state and doing their responsibility for them at the cost to New Orleans taxpayers makes no sense for us. And so we've asked the sheriff and the Secretary of Corrections to get those state inmates out of Orleans Parish Prison. So let's keep a size jail that is necessary to take care of our local inmates, but we don't need the capital cost and we don't need the operating expense to take care of somebody else's prisoners.
Instead of asking how many people can we hold, let's ask this question: how much money do we have that we're willing to devote to the jail, as opposed to substance abuse, mental health treatment, addressing the homelessness issues, jobs, etc. This pie, how much money are we going to devote to the jail? And with that amount of money, how many people can you safely, securely, humanely, and constitutionally hold? And that's the size of our jail.
The jail size number is a question mark. The New Orleans police, meanwhile, are budgeted to add 150 officers this year. So far, they haven't been able to fill a class of 30 recruits. The consent decree may play a role.
New Orleans police engaged in a pattern or practice of conduct that was both discriminatory and unconstitutional, and that too often undermined the public's trust and the city's efforts to effectively prevent crime.
July 2012, the city and federal government agreed to a massive consent decree to fix the New Orleans Police Department. But it took until August 2013, with a federal court appointing a monitor team, for enforcement to begin.
428 deliverables that are in the consent decree. We have to do 428 things. We have a unit inside the police department that's ensuring we're following those policies and practices. The monitors are here now. They have been looking at policies and practices. When we turned over the policy and procedure manual of the police department to the monitors in September of 2013, We had just rewritten the entire document. It's over 1,000 pages.
But in the Monitor's first quarterly report tracking consent decree compliance, they point out that NOPD broke the rules. The NOPD's implementation of its new policies in advance of their review by the Department of Justice and the monitoring team has created the risk that NOPD now will have to retrain personnel, which of course could cause added expense, delay, and confusion among the rank and file. Since the monitoring team has identified shortcomings in the new NOPD policies, the consent decree's intended review, then implementation structure appears to have been well justified. The monitors did give the city credit for taking steps forward and pointed to the new body cameras worn by officers on patrol. The consent decree requires every patrol car have a camera, but Chief Serpas went further and received Monitor and Justice Department approval to deploy 420 body cams.
There's no more he said, she said. It is what it is. It's unvarnished. It's a factual representation of what happened. The officers around the world actually are supporting the body-worn camera because they also would like to have on their side some independent video that says, no ma'am, I didn't curse your child. No ma'am, I didn't call your child out of name and throw him over the hood of the car. That is going to be very powerful for all of us to move past what's the original disconnect. It can either help us train officers better who might need individual training, or it can certainly help us explain to somebody, here's why we did what we did. This is why those behaviors and actions occurred. And ultimately, if an officer has lost our faith and confidence, then the video can help demonstrate that they need to move on to another opportunity in their life.
There is some officer hesitation about the new cameras, but their loudest complaint is consent decree creation of a city-run office for coordinating off-duty detail work. Many police consider their second jobs the trade-off for low pay. Local police organizations fought the change in federal court and lost.
Those 10 pages of the consent decree have had a greater impact on the day-to-day lives of the officers than any other part of the consent decree.
The detail system with the New Orleans Police Department used to be free market. And now, with the creation of the Office of Police Secondary Employment, which was required by the consent decree, the fees for details are now set by the OPSE along with the City Council. So we've gone from a free market to a controlled market. So the controlled market, in addition to some of the requirements mandated by the consent decree, such as officer rotation and advance payment, have definitely caused consumers to go to other law enforcement agencies looking for detail services. And those other law enforcement agencies are able to provide those services, and they are doing that. So the end result is a significant loss of income for our police officers. And absolutely, that is an impediment to both retention and recruiting.
As CEO of the New Orleans Police and Justice Foundation, Melanie Talia is steering the online campaign JoinNOPD.org. It kicked off in August 2013 to help the police department meet its goal of a force of 1,575 officers, up from what some call a critically low count of about 1,150.
One of the hurdles we had to get past, though, was at the city level. At that point in the game, the only way to apply was either by mail or to actually come and hand deliver your application. There was not yet an online application system. So we got an online application system that went live right at Thanksgiving. Well, between December and today, we've had more than 30,000 visits to the site. We've had 1,200 online applications. More than 400 people have been set for testing, which is huge.
What's happened is there hasn't been a wild increase one way or the other in the number of people who are leaving each year. What changed is we weren't hiring because of the dramatic budget problems we faced in 10, 11, 12, and 13 to offset. That's just exactly what happened.
Councilmember Susan Guidry co-authored the change exempting first responders from the domicile law that says city workers must live in New Orleans.
If it helps 5 guys who live in St. Tammany or St. Bernard to decide that they'd like to work for the New Orleans Police Department, then those are people that might not have otherwise applied if they had to worry about moving their families and relocating, buying housing. Housing's not all that inexpensive in the city of New Orleans these days.
We have an entire culture that needs to be changed within Police Department. So the increased training, particularly the sensitivity training, and a lot of the requirements of the consent decree, I think are excellent. And I think over time they're going to help create a much better police force for New Orleans. But I think right now we have got to deal with the police shortage and with the paid detail issues, or we are going to hit a low that it will be hard to come back up from.
We have to find a way to pay for looming liabilities from the firefighters' pension fund and federal consent decrees and build a police department with 1,600 officers so we can make our city safe.
Paying for priorities and punishment for problems started long before their watch is the puzzle for city leaders as they begin their new terms. First Deputy Mayor, Chief Administrative Officer Andy Copeland says the NOPD consent decree should cost $55 million over 5 years, but the sheriffs could cost $130 million over that same time.
It could leave us in a position where we're actually taking cops off the street to put sheriff's deputies into jail. We're committed to making those reforms in the police department. We've stepped up, we've budgeted those funds. We're committed to helping the sheriff produce a constitutional jail, but the timing and the sources of money to do that need to be negotiated in an appropriate way. We're not going to solve every problem overnight in either the jail or the police department. We need to make progress, and we need to do so in a way that doesn't cause us to have to overburden taxpayers in New Orleans, because of course we're coming back from Katrina.
There's a new move underway to save taxpayers across the state some of the hundreds of millions of dollars they spend each year on our prison population. Louisiana has the nation's highest rate of incarceration, and it's starting to look at what neighboring states are doing to reduce the number of nonviolent offenders behind bars. More than 39,000 state-sentenced adult offenders are locked up by the Louisiana Department of Corrections. Less than half are assigned to 12 DOC facilities, like this one in St. Gabriel. The rest are held in parish jails or work release centers. This year's DOC budget is $648 million.
Conservative business leaders have gotten together, looked at the math on this, and decided that not only are we spending way too much money to keep people in prison, we're not even safer as a result of it. In fact, we might be less safe, because being in prison doesn't really prepare most people for anything except problematic things when they get back out.
Michael Cowan is chairman of the New Orleans Crime Coalition. His group is part of a team of institutions and religious leaders studying what other Southern conservative states have done differently.
And in Texas, they have succeeded in reducing the incarceration rate, saved a lot of money, and crime rates have been dropping. So it's been a success, on every front. And one of the keys to what they've been doing is not incarcerating as many nonviolent offenders and building up their alternatives to incarceration. So if you have a drug addict who would really benefit more from treatment rather than from a long stint in prison, you give them that treatment. And in many cases, they're able to reintegrate back into society more successfully.
Kevin Kane is president of the Pelican Institute for Public Policy, one of the leaders of the push.
And so we have a number of bills that we're supporting in this legislative session, although of course we recognize this is really a long-term project. Well, there are a couple bills that would just make more people eligible for parole consideration. It doesn't mean that they're going to receive parole, but just makes them eligible for consideration. Because what we've done is we've put a lot of people, again, many nonviolent people, drug offenders, away in prison, and they're not even eligible for parole consideration. Another thing is removing barriers for ex-offenders who want to get back into the workforce. That's a big issue here in Louisiana.
Real estate developer Press Kabikoff is one of the founders of Smart on Crime. He says the state's energy, manufacturing, and construction growth will create 42,000 job openings in southeast Louisiana alone.
And we take a whole lot of people that are really nonviolent, non-dangerous out of the job market. So that's not good for our economy. And then finally, if you live in the city of New Orleans, you realize that mass incarceration changes to the complexion of entire neighborhoods, particularly African American, where so many people in those neighborhoods end up in jail, it becomes the apparent future for these young kids. And so it has a very destructive impact on our city and then all around the state.
Kabakov and others looked to Texas. In 2007, the state projected nearly 18,000 more inmates by 2012 and faced a $2 billion tab to build new prisons.
We didn't do that. We stopped that. We gave people a second chance. We gave those people with small amounts of drugs a second chance with things like drug courts, specialty courts, that intervene in their lives and help them instead of sending them off to prison and away from their family. What kind of taxation do you get from people who are locked up in the prison?
Jerry Madden was corrections chair of the Texas State House then. His work helped Texas close 3 prisons in the last 3 years. Now he's helping the Louisiana Smart on Crime team. He testified in Baton Rouge before a Senate committee hearing a bill to make second and third offense simple marijuana possession misdemeanors. Sheriffs and district attorneys from all over the state showed up in opposition, and the bill died.
The bill is deferred.
I think there is opportunity for collaboration, and as a matter of fact, almost all the other bills in our package are moving through without opposition. This one, again, because it involves drugs and sentencing for drug crimes, that is a hot button issue. So I think we have some work to do in terms of educating people. But I do think that there's absolutely room for working together and collaborating, because when you look at what's happened in other states, the DAs and sheriffs have played a key role in some of these reforms.
Thank you for joining us. Our next edition of Reshaping a Greater New Orleans Criminal Justice will focus on the issues in the elections for district attorney and criminal court judges in the fall. Look for the latest at WYES.org. Reshaping a Greater New Orleans Criminal Justice is made possible by Baptist Community Ministries. Founded in 1924 as Southern Baptist Hospital, Baptist Community Ministries is committed to the development of a healthy community, offering a wholesome quality of life to its residents and to improving the physical, mental, and spiritual health of the individuals they serve. Baptist Community Ministries is a nonprofit private foundation registered in the state of Louisiana and is committed to the Greater New Orleans region. For more information, visit www.bcm.org.